Well, good morning. I'm very pleased to be speaking here, and I thank Karen and Marnie for inviting me. None of us can thank Brad Miller in this situation for the panel now being without Canada's arguably leading expert on proportionality, and it would have been great to have him here. And of course, you're stuck with me now, so I hope we muddle our way through. The Oakes test interpreting the circumstances in which governments may impose a justified limit on a charter right is surely the most repeated mantra of Canadian charter jurisprudence. Mr. Oakes committed his crime at just the right time to be referenced more commonly in the Supreme Court of Canada than even Peter Hogg. The proportionality analysis that the Oakes test embodies is a central feature of understanding the practical content of rights and freedoms that we care about. Yet, that proportionality analysis is almost immediately recognizable as more complicated than any simple account would suppose. From its very origins, we can actually start to identify issues with the Oakes test. In Oakes itself, the court articulated the test that called for an analysis of the four parts of it: the importance of the government objective that results in a rights limit, the rational connection between the limit and the objective, the minimal impairment of the right relative to other means of achieving the same government objective, and an ultimate balance between the rights limit and what's achieved by the limit. On the facts of Oakes, the court was considering a charter challenge to a reverse presumption under which someone convicted for possession of a narcotic would be presumed to be in possession for the purposes of trafficking unless he or she refuted that presumption. The court held that this law failed the rational connection branch of the test that it had established in the case. That view is, of course, mistaken on its face. This law might have been poorly designed, and it may well have failed other branches of Oakes, but it actually defies comprehension to say that a law making proof of trafficking simpler didn't have a connection to the achievement of a government objective of discouraging trafficking. So right from the outset, the Oakes test has been subject to peculiarities. It's a peculiar sort of test where the court struggles to apply the test in the very case where it's created it. Today I'm going to tell you that proportionality analysis in the Oakes test has been subjected in Canada to various myths. In fact, to 5.5 of them, to be precise. Maybe more, but I'll run out of time after 5.5. So, myth one is that proportionality analysis is a uniquely Canadian invention. The Oakes test didn't simply originate in Oakes. It does draw on deeper traditions of law, and it now is part of an international discourse on proportionality. In fact, the Oakes test has been written essentially into the text of another constitution elsewhere in the world, with the wording of Oakes appearing in a very similar form in the South African Constitution, as just one example of a place that Canada's Oakes test has helped to influence. But it's been in the context of proportionality analysis being under discussion in different places around the world all at the same time. The deeper origins, though, can be traced back further into jurisprudence of the European Court of Human Rights, through that back further into German administrative law principles of a century ago, and even on back to deeper origins, some of which were referenced by Justice Lebel in the context of his call for revisiting and possibly reforming the approach to proportionality analysis that has taken hold in recent years. In his dissenting judgment in the case of Alberta and the Hatarian Brethren of Wilson Colony, a religious freedom case from 2009, Justice Lebel ended up writing as follows: "In its own way, the Oakes test is yet another attempt to determine why and how a law could be found to be just and whether it should be enforced. Many centuries ago, St. Thomas Aquinas put his mind to the same question. For him, a just law was one with a legitimate purpose which relied on reasonable or proportionate means to achieve it." And the passage goes on a bit from there. So Justice LaBelle ties the proportionality analysis back to deeper historical origins, the writings of Aquinas. He doesn't mention long-standing philosophical and even religious writings on the same principle that would have predated Aquinas. But Justice LaBelle's discussion does highlight the basic point that I would make on this first myth. Our engagement with law, and with constitutional rights and freedoms in particular, requires a deeper engagement with the philosophical traditions that our legal system carries forward. Fundamental freedoms did not come into existence in 1982. The history of human thought started before Woodstock. John Locke probably offers deeper insights into the meaning of parts of the Charter than various screaming banshees of certain prevailing Charter orthodoxies. Contrary to the modern myth, a classical tradition of rights and freedoms is a necessary starting point for understanding the Charter. Myth 2. A Canadian division between internal and external limits on rights is sometimes said to enhance respect for rights by offering a way of reading rights more broadly and only then considering limits on them. The Canadian Charter, in its text, of course, does put a specific provision on limits on rights in a separate clause in Section 1. The Supreme Court of Canada early on ended up drawing on that textual structure in Oakes and other cases to conclude that it would develop a system under which rights are understood with very few internal limits in a number of cases. Rights claimants get a matter into court relatively easily, and then the burden is put on governments to try to put forward evidence of a justification for the law. This is the model that the court describes. For the court, and for various charter mandarins of the 1980s, this approach allowed rapid attacks on various laws and enabled rights claimants, often taxpayer-funded, through various mechanisms, and then forcing the taxpayers to spend money to try to put forward a justification for long-standing legal approaches, but enabled these attacks early on. But at a more principled level, the claim was that this better enhanced respect for charter rights by enabling charter rights claimants to go forward. However, and to put the government to the test to justify a law. However, as scholars like Brad Miller have highlighted, and I really wish we could have him here because he would be great to have here. But he's great to have on the court too. As scholars like Brad Miller have highlighted, there's a cheapening of rights discourse that emerges from these approaches. What we end up with is a situation in which rights are routinely said to be violated. We can be more precise and say that they're infringed, but that will often quickly get turned into that somebody's rights are violated, and then some violations are justified and some not, based on the say-so of a court at that stage carrying out a Section 1 analysis and reading some social science journals and going through the Oakes test. We end up in a situation in which the prima facie violation of rights by the state is a routine condition that we're expected to live with, and in which no distinctions are drawn in some of the internal limits on rights. In some of them, there are actually no distinctions drawn between legitimate and illegitimate branches to those rights, as would have occurred under approaches that do consider how far rights should or shouldn't extend. Instead, the consideration of limits is left to the Oakes test, to the proportionality analysis. And Brad Miller's writings show that even those branches of the Charter that would have operated differently, like Section 7, have become more and more infiltrated by the approaches that the court has offered on Section 1, leading to a further alteration of the rights analysis from how it would operate with more internal limits on the rights. We end up in a culture then where rights themselves are understood as things that can be violated based on various state justifications, and in the process, rights are arguably cheapened rather than better respected by this mode of analysis. The third myth that I'll argue here is the suggestion that the Oakes test enables consistent decision-making. And this is certainly one of its purported aims. In principle, something like the Oakes test provides a necessary structure for judicial analysis within a system where judges have a variety of different opinions and could use a variety of different approaches on their own. If courts operated with no precedence on the scope of rights and just made their decisions based on what each judge felt about the application of the Charter, we would end up in a bad state of palm tree justice. The Oakes test tries to provide a rubric for analysis for judges, lawyers, and citizens, putting it at its best. However, at the same time, the Oakes test actually enables real potential for inconsistency of result, I would argue, depending on how cases make their way to court or to some other decision-making forum that purports to apply the Charter, whether an administrative tribunal in some form, whether a law society, whatever the case might be. And this point, myth 3, is arguably the trickiest one that I'm going to try to engage with. I've tried to describe it more in writing elsewhere, but I'll try to articulate it as best as possible. My claim is that depending on who gets to be the rights claimant in a particular case, the outcome on the same policy issue can conceivably turn out differently, even though the court should be considering arguably the same factors. And this is particularly the case when we start to hit conflicts between rights, particularly as between expanded equality rights and traditional fundamental freedoms, or as between equality rights of different groups. Now, I'm going to use a specific example, but any example that we would pick concerning conflicting rights obviously has arguments on both sides. In fact, rights arguments on both sides. And often there will be good classical liberal arguments on both sides. So people who hold very similar views might come to very different outcomes on the same case, depending on the arguments. But what shouldn't ideally happen is that the courts would come to different outcomes based on how the case makes its way into court. I'll give the example here then of a case on which people in this room are probably going to have differing views. The example of the reference question that was sent to the Saskatchewan Court of Appeal on a hypothetical government scheme to exempt marriage commissioners from performing same-sex marriages if they had religious objections to doing so. So this is the Saskatchewan Marriage Commissioners reference. Because of this way in which the case was put, a potential legislative accommodation of religious freedom was subjected immediately to a charter challenge based on equality rights claims by individuals from the LGBT community. The Saskatchewan Court of Appeal ended up holding the potential legislation to be unconstitutional. Chief Justice Richards did so based on the minimal impairment branch of Oakes, saying that you could accommodate the religious views of those marriage commissioners in a different way that would have fewer negative effects against the equality rights of LGBT individuals. And he did so after hearing a description in court by a lawyer arguing against the law who described a different approach to such accommodation that was allegedly operating in another province. There's been some indications afterwards that that other approach may not have actually been in operation in that other province in exactly the way described, but it was at least a hypothetical different approach that seemed to offer a more minimally impairing approach than that proposed within the legislation. Based on the structure of the case and the way that the proportionality test worked, religious freedom had to be justified against challenges put based on equality rights. But had the case been put the other way around, if a charter case had been squarely put on religious freedom grounds against a government decision not to accommodate religious differences, the case might well have played out inconsistently with the case as it made its way through the Saskatchewan Court of Appeal on this reference, One could envision easily a court ordering the provision of an accommodation of religious freedom, or not. I wouldn't want to make the definitive claim that that would have been a winning case, but its prospects would certainly have been increased by the claim being put on the other side, even though the policy question is essentially the same in both instances. There's, of course, a practical implication and indeed a justification for groups like the CCF that comes out of examples like these. And this, as I say, is just one particular example where there's a case that illustrates a point about the way in which a case comes to court because of the way this proportionality analysis works matters. For a long time, those principally working to advance different parts of the Charter than those that may be the main interests of the CCF have put cases sometimes at the expense of the fundamental freedoms within our classical rights tradition. Given that the Charter is a reality today, there's not going to be a constitutional amendment removing the Charter. It's important that there also be rights claimants going forward on behalf of classical liberal freedoms if those are to receive a protection under the Charter to the extent that they can, particularly in the context of complex questions about balancing potentially conflicting rights in various situations. And we can come up with a whole array of those, not always involving equality rights, but involving other rights as well. The CCF's contributions through public interest litigation can over time help to balance out the Charter jurisprudence in different ways. Now I'm going to address the half myth in order that I can't end up running out of time and having to just deal with one of the myths and get only halfway through. My title might have seemed peculiar in speaking of 5.5 myths. Well, we're sort of at the halfway point, and so it's a good time to talk about a half myth, just to differ a little bit. The half myth is that the Oakes test puts the burden on governments solely to defend laws against Charter rights claimants. Now, I actually said something much like that before. That's why I say it's not entirely mythical. The Justice Department budget would bear out some of the truth in that. The ever-expanding timeline to conduct a criminal prosecution in the face of various Charter motions and the results of that would bear out that claim, that in fact the government is put to the test of justifying different laws under the Oakes test. But rights claimants face an uphill slog as well, more so than on the initial description that the Oakes test might have led us towards. Rights claimants that are going to challenge a government justification through the use of their own evidence on various policy aspects that the Oakes test allows into question end up needing, in some cases, depending on the issues at stake, to file voluminous records of material in order to provide the evidentiary basis for the application of the Oakes test. One public interest lawyer that I heard speak recently, who may be on the different side from the CCF in various cases, made a claim that in a particular test case that her organization was pursuing, that had a judge not permitted the use of an electronically filed record, the printing costs alone for the required filing and copies of the filings would have actually been into the hundreds of thousands of dollars. Now, this speaks to the amount of paper that's being printed in some of these cases. The judge did, in fact, permit an electronic filing, but there are obviously other costs that are connected with producing that kind of record, with putting argument on that kind of record. And in that sense, there's a real burden on rights claimants as well if they're going to try to put the argument in some of the cases where that kind of record is necessary. Now, we could draw out a crass implication of this. I'm offering various critiques of Section 1 analysis, but I also don't think that the court's going to fundamentally change it. If you came to hear a critique with some hopeful comments about a different possibility, you've come to the wrong place for that. On Justice Binney's view articulated last night, we wouldn't critique decisions of the court unless we can offer a definitively better approach. But we can still talk about some consequences of the approaches that are there. And on another occasion, we could talk more about some different alternatives, I think. But at the moment, we live within an existing system and need to muddle along. Well, the crass implication that arises from the half myth, from the side that I've just drawn out, is that test case litigation can cost a lot of money. And anyone who supports the work of a particular public interest litigation organization, I don't know, hypothetically the CCF, might consider donating money to the organization that they're seeking to support. Constitutional litigators might be underpaid, but it doesn't mean that constitutional litigation comes cheap because of some of these costs that do arise from aspects of the Oakes test. Myth 4 is that proportionality analysis applies just to charter rights. Proportionality analysis of the sort discussed in Oakes actually has wider implications that are often silenced. One example is in the context of Aboriginal rights, which appear in Section 35 of the Constitution Act 1982. They are outside of the Charter, which is contained in Sections 1 through 34. There are many mistaken statements that get made on this, where Aboriginal rights get referred to as charter rights, even in one example I found by the Federal Court of Appeal. And it's an unfortunate misunderstanding. But Aboriginal rights in Section 35 are part of the constitutional text where the court was forced to make up everything, essentially, in the context of a text that said almost nothing. The words say very little about the contents of Section 35. And where there was much more limited history on the interpretation of those rights as compared to rights like freedom of expression or other charter rights where there are hundreds of years of interpretation from the United States and elsewhere. Well, in this area, courts have articulated more nuanced judgments than are sometimes realized or reported. Various judgments that are presented as being very definitive one way or the other often contain complex balancing factors within the judgment. Even though Section 1 didn't apply according to the text to Section 35, the court here recognized that in understanding rights, it's necessary to understand limits on those rights, even where the text hadn't been as precise about that. And so here we see an instance of the court developing internal limits. And so cases like the recent Chilcotin Aboriginal title decision also see the court discussing at length the circumstances under which governments may justifiably infringe upon Aboriginal rights, or indeed override Aboriginal title in some instances. For a variety of reasons, and understandable ones, governments almost universally don't describe their powers in terms of the ability to, in some circumstances, infringe upon Aboriginal rights, at least openly. Even when billions of dollars are at stake in terms of a year after year loss to the Canadian economy from lack of access for products to markets. Even when there are situations where members of one Aboriginal community, not even necessarily a majority in one Aboriginal community, may block a project that's supported by a number of other Aboriginal communities, and this is a different pipeline than is most under discussion. But in situations where different groups' claims are being balanced out, there's actually very little forthright discussion of what the precise legal position is, and the complex balancing decisions that might be made under the approach that the court has articulated, which usually gets described as being much less nuanced than it actually is. The fifth myth that I'll mention briefly in the context of proportionality analysis is that proportionality analysis, or the Oakes test, or these kinds of tests can provide a predictable and stable jurisprudence. Proportionality analysis, as it has been functioning in Canada, is actually opening everything up for redebate. It's possible to redebate legislative facts, maybe not even just once, but over and over, because the elements of the proportionality test are actually factual elements on which trial judges will engage in fact-finding based on the record in a particular case. And in the Bedford decision, the Supreme Court of Canada ended up saying, in essence, that trial judges should feel free, subject to some limits, but should feel reasonably free to engage in, I don't think they use the term, but they say trial judges should feel free to engage in anticipatory overruling of past decisions of the Supreme Court of Canada, where factual circumstances have shifted in certain types of ways. That kind of pronouncement doesn't provide much stability in the jurisprudence. And we've seen that in recent years where there hasn't been stability in the jurisprudence on labor rights, on Section 7 issues ranging from prostitution to potentially euthanasia, on anything else where there are key charter determinations. Everything is thrown for debate again upon the accumulation of a new factual record. And it may need to be an extensive record. It may be a costly record to produce. It may be a record that takes time to produce. So the challenges to Parliament's reframed law on prostitution may not be coming next year, but they'll come a decade down the road after the accumulation of more empirical material. All things are thrown open to debate over and over again. Those who lose in democratic forums can put their arguments in the courts, and those who have views to articulate in the courts ought to do so on all sides. Proportionality analysis is a key area of charter jurisprudence, and I suggested in my comments that it's one subject to a number of what I've dared to call myths. Let's just call them things to think about, to realize that this is an area raising a lot of important questions, and one that raises some real challenges in the context of the kinds of constitutional litigation that we're all interested in. With that, I'm happy to engage in questions and comments.
Administrative law is growing. The administrative state is ubiquitous in Canada. And in the recent Doré decision, the Supreme Court seems to have changed the test completely. Now we don't need a demonstrably justified test when the state interferes with fundamental freedoms. Now it's just a reasonableness test when it's within the context of administrative law. Do you have any comments on that? Is that a troubling development for constitutional freedom in this country?
Well, there are a variety of different things we could say about that, because, of course, administrative law is so diverse. And there's an early judgment of Justice LaBelle where he references that diversity of administrative law and says something along the lines that when you think about milk boards, and you think about police commissions, and you think about he didn't mention pipelines, but when you think about this diversity of things, so energy boards, you're really talking about an area of law that's dealing with things as diverse as pipelines, cops, and cows. And so the implications of approaches in administrative law for constitutional freedoms, I think, are going to be complex across different areas of administrative law. Certainly, to the extent that, that the Dore decision ends up enabling certain kinds of challenges or impositions of the administrative state upon constitutional freedoms more readily, it may have that implication. But I guess I'd just say that there are some other contexts where administrative law does have different implications, and it's the diversity of the area that I think creates some complications in how I'd answer that question. So I might just leave it at that and say, in the classical law student answer, it depends. So.
On this issue of the Saskatchewan marriage commissioners, I've heard a proposal that that if a government were to, provincial government were to have 3 categories of marriage commissioners, so those who wish to become a marriage commissioner, regardless of their personal religious values, could apply to have one of 3 categories. The first would be A, for call it, they would perform all types of marriages. B would call it gay marriages only, same-gender marriages. And perhaps C would be traditional or conservative marriages, the traditional man-woman marriages. Now, if that were implemented, if that were passed in legislation by any provincial government, what is your feeling as to whether that would be upheld? The reason I say that, as I mentioned, is that then the issue of the personal religious values of the marriage commissioner are simply not exposed. Someone could, someone who was a previous, call it, one of the cases was a previous Baptist minister, no longer the minister, but a pastor, but then he became a marriage commissioner, but he refused to perform those gay marriages. But with that 3 categories, then it's up to the individual commissioner to apply. What's your opinion on the perhaps constitutionality of that?
Well, the Saskatchewan Court of Appeal, in addressing this issue, was really concerned to identify a system under which there wouldn't be a visible refusal to any same-sex couple. And the system that was proposed by the government would lead to a marriage commissioner referring a potential same-sex couple in some circumstances on to another commissioner. And with that couple being aware that they'd been refused. The court ended up saying that if they ran a system that had the allocation of marriage commissioners operate invisibly to those seeking a marriage commissioner, that would be less infringing. The kind of system that you're describing, if it operated invisibly to those seeking the services of a marriage commissioner, would be then similar to what they said would be less infringing. If it operated visibly to those seeking the services of a marriage commissioner, it would run into the same problems as the system that the court ended up rejecting, which is that they would say that there's something that's less impairing of the equality right at stake. So it would depend on the details of how it was implemented as to whether it would increase the chances that a court would uphold it. The reasoning of the court, of course, assumes that that there's a violation of equality rights in people becoming aware of the fact that there's someone who disagrees with them, in a sense, although in the particular context of someone performing a government service, which is a very important element to the case. So there are some complex balances at stake within the case. And as I said before, I think people in this room probably have a variety of different opinions on what's the approach to reconciling the different matters at stake. But creativity in finding ways to try to address the claims of all certainly is always a good thing.
You've painted a rather dismal picture of our proportionality jurisprudence, and I'm not particularly sympathetic to this, but if it takes all these resources and this is how we're going to make public policy in this country, would it make sense to have government funding for constitutional litigation? yeah, exactly. If this is how we're going to decide these questions, is there room for that, or what's the best argument against that?
Does there need to be government funding for people to participate in democratic processes as well? You might respond that there's a difference here because there's the need for specialized services to access legal counsel, obviously, in the context of putting a claim in the courts rather than through democratic processes. But the reality of a modern democratic process is that it takes money too. And people that have views on different issues need to engage in various ways, not just through going and marking a ballot, but also in offering funding to political parties that they support, in funding think tanks, in funding others. And I guess my initial response would be that I'm not sure that the courts become any different in the context of if they're a forum for debate over issues that would have been democratically debated before, people would have faced costs in engaging in those debates. Those costs are shifted to a different context, and I don't think that it leads me to immediately say that there should be government funding. But there's more one could talk about on that, but that's my quick response on it.